should see a notice that it's recording and need to give your approval to continue. If and not to be rude, but if you've got sounds coming through your audio, I'm going to go ahead and mute you. That's not to say we don't want you to participate, but just to keep the sound down. So welcome, everyone. As folks know by now, I think this is a monthly meeting we hold for, started off with grantees under the BJA grant for upholding the rule of law and preventing wrongful convictions, but since then we've greatly expanded out pretty much to anyone who does post-conviction litigation and investigations, because the topics that we tend to cover are really pretty universal for folks. I would encourage people as you're joining to keep your videos on if you're comfortable, just because it helps with the presenters to kind of know that there are folks out there who are listening and are going to be participating, we hope. As always, we very much encourage people to participate. You can ask a question in the chat. You can raise your hand at the bottom of the screen and where it says reactions. If you click on that, you can actually raise your hand, and I'll be able to see that. If you just physically raise your hand, I won't be able to see that because we have so many people that you're on multiple screens. But feel free to chat, send me a personal chat, raise your hand virtually, and we'll be able to get your comment or question to the folks who are presenting. So this month and next month, we're going to be working on issues related to live suspect investigations for those in post-conviction litigation. So obviously the case could arise where a defense lawyer, innocence organization is working on a case, and they have developed who they believe is the actual perpetrator for the crime, bring that to the prosecutor's office. And then what does the prosecutor do with that and how do they proceed? Or of course, the prosecutor through their own investigation could have developed their own suspect and need to follow that through. So we have this, I'm going to call out Lauren Lipscomb because this is all her fault. She started out with, we were discussing what would be useful for COU directors who have never been prosecutors before, and understanding that a lot of you are in that position. Dealing with live suspect investigations are very nuanced, very layered, and very complicated. So we thought this would be a good resource for directors. But of course, those of you who run innocence organizations or defense counsel, have never been prosecutors. Of course, this is information that will be helpful for you as well. I think I will own it myself. When I was a defense lawyer, innocence lawyer, I really had no idea just how all the complexities and the ethical issues that are involved on the prosecution side for some of these matters. So understanding what the process is and what they have to go through, we hope will be helpful for anybody who is involved in this work. So today, it's kind of part one. So your moderators today will be Carolyn Murray, who is a New Jersey former judge, but now runs the Conviction Integrity Unit for the State Attorney General's Office, and Cynthia Garza, who many of you know, who has been helpful with us before, and has been a stalwart director for CIU in Texas. We have several kind of folks who are pitching in today. Lauren Lipscomb, as I mentioned already, and Linda Ramirez from the Baltimore Conviction Integrity Conviction Review Unit. And I apologize if I get review or integrity wrong on your independent units. They will be talking about kind of an overflow of what a live suspect investigation entails from the prosecutor's standpoint, whether to bring defense counsel into that investigation or not, and how to understand the needs of the applicant's counsel, that is the person who is applying to CIU for relief from a potential wrongful conviction, their need to get information to how do prosecutors kind of balance those particular needs of communication. Sarah DeSimone, who is with the Middlesex County District Attorney's Office in Massachusetts, will talk with us about balancing the ethical issues that are involved in these kind of parallel investigations from the prosecutor's view. How do you go about an investigation with it means potentially delaying relief for a potentially innocent person, and various difficulties that prosecutors have to do when they're conducting these live suspect investigations parallel to an innocence investigation. And finally, Mark Hale is coming out of retirement to address us and talk with us about dealing with inter-office issues that arise through live suspect investigations, balancing the needs of the trial team with the needs of the CIU, of course, dealing with anybody who may be on staff who may have been involved in the investigation, how do you handle those kinds of conflicts as well? Then Mark, of course, was a 37-year prosecutor and has been, was running, the Conviction Integrity Unit at King County, Brooklyn, New York, until his retirement last week. So first, thank everybody for being here and for participating in this. I'm going to ask folks who are not talking to mute yourselves to limit the amount of background noise that's coming through. And as before, if you have any questions, please put them in the chat or raise your hand virtually and we'll get to them. I do have one quick request, which is a poll. So I've been, as many of you know, data collection and data review has been a big part of the work that we've been doing at the Quattrone Center to try to help CIUs and innocence organizations out. I've had some meetings with some developers and I'd like to get them some data. So I'm going to launch a quick poll for you, and I'll just leave that running if you don't mind, Carolyn and Cynthia. And if folks could take the moment to just respond to that poll, I'd appreciate it. And it will be very helpful for us to try to hopefully get some resources out for folks who want to increase their data collection. So with that, I will hand off to Cynthia and to Judge Murray.
Thank you, Marissa. I appreciate it. Hi, everyone. Thank you for being with us this afternoon. You heard Marissa talk about live suspect investigations. What does that mean, right? Some of us have heard the term, some of us have never heard the term, and some of us use a different term to describe what that means. So, Lauren, if you could kick us off with just introducing what a live suspect investigation means in the context of innocence investigations. And then also tell us about how the issue arises, how you investigate the general flow of the investigation in this type of case, this type of situation, and any various concerns that we would have as prosecutors when we have this type of investigation going on that differs from the traditional type of investigation. So Lauren.
Thanks so much, Cynthia, and thank you all for having me here. Just really briefly, I know that all jurisdictions are set up differently. We all have a shared goal, but we certainly even right down to whether we are state's attorney's offices or district attorney's offices. So just to give you a little bit of background, in Baltimore, we have a state's attorney's office. I'm a career prosecutor. For those of you who don't know, I've relied very heavily on colleagues from other jurisdictions to get our program here in Baltimore up and running. I was the chief of the Conviction Integrity Unit up until a few months ago, and I've actually since been promoted into a deputy state's attorney's position where I oversee not only conviction integrity, but several other units as well here in the state's attorney's office. So our program here in Baltimore is relatively new. It's about 5 years old in terms of a formalized process for reviewing these claims. The first thing that I would point out is that it's really the stage that we're in. As Marissa touched on at the beginning of this, this is a relatively complicated area of the conviction integrity, conviction review work. If you are fortunate, like here in Baltimore, we were not, maybe you don't have to confront this issue until you're a little bit longer up and running and more formalized. However, this issue presented itself in our second exoneration. So we've had 10 exonerations and we have 10 exonerated persons representing, I believe, 6 cases because we had co-defendants. And in our second case, our second exoneration, we were confronted with a live suspect. So what we mean by that here in Baltimore is that we have an individual who is alleged, or it's an alternative suspect or a person that's being alleged to have committed the offense, which is on the street or is in some capacity not arrested for this particular case, and is also not serving a sentence of any length on another case. So the second exoneration that we had here in Baltimore was a situation where a live suspect was presented to us and that individual was actually on the street. And so there are various issues that are confronted almost immediately that we are confronted with almost immediately when we have these types of scenarios, because at the end of the day, And I'm so grateful that we're having this conversation. And if I can back up, I am going to be really just talking, and I see this as more of a discussion. So please feel free, anyone, to put any questions that you have in the chat or interrupt me. That's totally fine. If you want me to slow down, or if you have a question about anything I say at any point, please feel free to interrupt me or put something in questions into the chat. What I would point out is that with the live suspect cases, if you step back, really conviction integrity and conviction review units may serve different functions depending on what jurisdiction you're in. So here in Baltimore, our conviction integrity unit only reviews factual innocence claims. So when you're sitting down, and we have a lot of discussion about how to form these units and get them off the ground and how to staff them and what kind of work you're going to be doing. Well, when you get a little bit further along, and I'm sure Mark is smiling from ear to ear that I would even be talking from the context of being a little bit further along, considering how young and inexperienced I was when I came to him seeking advice years ago. But when you're a little bit further along, it's a lot more easy to conceptualize really what this process looks like in terms of when you're confronted with your office wanting to develop a conviction integrity or conviction review unit, you're immediately concerned with funding and staffing. When you move on from that, you've got to try to develop what universe of cases you're going to be considering. Factual innocence, procedural issues, sentence reviews, police integrity. There's some units that are going to opt to do all of these things, and there are some units that are going to opt to do some of these things. Our office does all of these things. However, it's not in the same unit. So in the conviction integrity unit here in Baltimore, we're only reviewing factual innocence claims. When we have a sentence review issue, it goes to a different unit. We have a sentencing review unit. So here in Baltimore, the universe of cases are factual innocence cases. The live suspect considerations, 99.9% of the time, are only going to arise when you're dealing with factual innocence claims and considerations, which is logical, but these are things that you oftentimes, as we did here, you're not really conceptualizing and recognizing as you're developing your unit when these issues will arise. But if it's going to arise, the live suspect complication, it would be in the factual innocence context, which of course is logical. The universe of cases here in Baltimore are that we review incarcerated persons. The offense has to be a felony. Violent felonies are usually going to get priority. And what we do not consider here in Baltimore, but I know that other jurisdictions consider, are whether or not all post-trial options have been exhausted prior to getting to the conviction integrity, conviction review point with the prosecution office. Here in Baltimore, we don't necessarily, it's really just case by case that we identify those cases as to where we are in the as to where the defense is in the post-trial realm of things. So in Baltimore, our formalized process very quickly is that we screen the cases. If they get through screening, we do an initial review. They get through initial review, we open up a reinvestigation. Then it goes into final review, and the state's attorney's decision is obviously the final direction as to where the cases are going to go and if we're going to release someone. One of the issues that you have to consider with an alternative suspect that's been presented is when it's been presented. So if it's presented to you by the defense as part of their presentation to your unit, then they already know about this suspect, and you have to approach the case. You have to consider what the credibility level is of the alternative suspect that's been given to you. You will have cases in the universe of cases that you're reviewing from the conviction, within your conviction integrity unit. You will have cases where the defense comes and says, hey, it was this person. And you take a look at that person and you're pretty easily able to see, no, that alternative suspect, that's a dead end. That's not a viable alternative suspect. However, we do agree that there's a problem, and this, your client may not have done this offense. That has happened here in Baltimore as well, where we've got the defense that's presented an alternative suspect. We don't agree with them on that. However, we do agree that their client didn't do the particular offense. And so when you're going through the considerations, if it's a credible alternative suspect, one of the things that we've recognized here is that you immediately have to put back on your prosecution hat. And that brings me to another point, which is that the big difference, of course, between a CIU and a CRU and the Innocence Project is that we are not the defense. We are prosecutors. In our jurisdiction, we are sworn officers of the court. We carry a badge, and we're considered a law enforcement agency. And so all of the ethical considerations and the investigative responsibilities that normally assign to a prosecution office, assign to the ASAs and whoever is executing the conviction integrity and the conviction review function in the office. And that's something that is very critical to remain mindful of, because at the end of the day, another major difference between our function and role and the Innocence Project function and role is that we still, or your elected official still has to answer to the public responsibility of who in fact committed this crime. Has the victim's family received some form of justice? The elected officials are still obligated to answer those questions within a prosecution office, which obviously is not something that in any way impacts the Innocence Project. And so recognizing that we have these unique roles, and making sure that in the spirit of collaboration, we respect the boundaries that each of us have, because of course the Innocence Project have boundaries as to their own clients and what they are and are not able to do, which is in the best interest of their clients. That having been said, it is critical, I think, humbly, to have a good working collaboration with the defense and with the local Innocence Project. And a good working collaboration from what in our experience has really been built upon mutual trust. And so when you get to a point where you've reached, where your agency has reached the end of where it can go in terms of disclosure during the investigation, that mutual trust kicks in. And hopefully at the point where you would have a situation where you've got a live suspect and you've got to start remembering all of the normal prosecution constraints that start attaching, like, for example, Fourth Amendment rights, Fifth Amendment rights, pretrial identifications. You don't want to become a witness in your own case. You don't want to be the star prosecution witness. If there's going to be a prosecution of the alternative suspect. So keeping that in mind as you proceed and as you collaborate with the defense and proceed and collaborate with the local Innocence Project or whoever brought you the case. Those are the kinds of things that you just want to consider. And remembering to do things like bring in an investigator or a witness whenever you're doing your interviews. Again, you don't want a situation where you're sitting there with the defense attorney and the witness, and it's just the three of you that are there, because what if you've got down the road, what if you have a situation where you are in trial? Who's going to testify at that point? And then, and as I touched on just a moment ago, remembering the constitutional rights that attach. That is just critical. Sometimes in the heat of the moment, as you are thoroughly investigating a factual innocence claim, remembering that the alternative suspect still has the whole panoply of rights that attach to any uncharged criminal defendant. And those kinds of considerations are things that are so critical, because at the end of the day, if it is possible to prosecute the correct person, the alternative suspect, the live suspect, then from the prosecutor's office, we are obligated to do that. And therein is the big distinction between what our role is and what the Innocence Project is their role is. And while we work together here in Baltimore very well, we collaborate very well, we've reached sort of a mutual understanding of where some of the boundaries have to be. And so when it comes to things like mutual or coordinated interviews of witnesses in live suspect cases, that is almost never going to happen when we're collaborating with the Innocence Project. It will almost never happen when you've got a witness, if no one knows what they're going to say, for example, or if we have a witness who might be subject to a pretrial identification procedure. That's not appropriate for us to have a collaboration in terms of the interview. Now, certainly if the defense is bringing us a witness, even if it's a live suspect case, then they already, by virtue of them bringing the person to us, you might still have a situation where you request that the defense sit outside the room or whatever, for whatever given whatever the circumstances are. But I would say that it's a lot less likely that you're going to have a joint interview when you've got a live suspect case that you're investigating at the same time as a factual innocence case that you're investigating. I just wanted to turn it back over to the moderators so that I don't because this is more of a discussion, I haven't really prepared much, and I want to make sure that I'm staying on task. So I'll turn it back over to the moderators.
Actually, Lauren, you just answered the question that was pending in my mind about how do you handle joint interviews of live suspects if a person hasn't been made, if you haven't been made aware of that person. That was our instinct, but we had not yet. Well, we actually have now once, but we're confronting it again. Like, how do you approach that? Can I ask if you've had the experience of having an attorney bring you a case and having interviewed an important witness alone on their side of the aisle?
Yes. Yes.
And is there any particular course of action that you recommend in that circumstance?
So we have had that happen, and we have pulled that same person in and done an interview with our investigator separate from the defense. So yes, we've actually had that happen several times. Yep.
Yeah, we've only had it happen once so far that I know of, but it was, a very well-intentioned attorney, I believe, with no criminal experience and really I don't think any litigation experience. So, but this is very helpful. I think, unless Cynthia thinks otherwise, only in the interest of time.
There was a point in the chat about kind of spelling out expectations among parties even before. I mean, we've talked before about the need for cooperation and collaboration agreements between counsel and how helpful they are. If the live suspect is involved, do you find yourself putting down in writing expectations of both sides of here's how this is going to go down, or is this more like a fluid process and addressing things as they happen?
So I could see the benefit of the full gamut. In our neck of the woods, we have an MOU that is a generalized MOU with the our local Innocence Project, which is the Mid-Atlantic Innocence Project, and we've also worked with the University of Baltimore Innocence Project Clinic. So we have a general MOU that's a general understanding for collaboration related to the grants that we have, but the narrative does drill down into a little bit more of the collaboration. However, I could see a universe that makes sense where you would have a much more specified MOU drawn up for these instances where you've got a live investigation, a live suspect case. I would say that depending on your jurisdiction and depending on the relationships that you have, would really probably drive whether you feel the need to have such a detailed MOU, or whether you might want to just consider a general MOU that doesn't get down to, when we bring in a witness, this, these three things are going to happen. I think it would just depend on the trust and the collaboration comfort level of your jurisdiction.
So maybe that's a good segue into our next presenter, Linda, who was going to discuss the issues about wanting to maintain a cooperative investigation. I'm sorry, a cooperative relationship, but having to pursue an ongoing investigation. And I believe that Linda can give us the perspective from someone who has defense experience, which would be very beneficial to many of us who really have spent most of our careers on the prosecution side.
So, hi, everybody. I'm Linda Ramirez. I'm the CIP, the Conviction Integrity Program Prosecutor in Baltimore City. I work with Lauren very closely, and we have an investigator and a law clerk. I have 25 or so years experience as a defense lawyer, both as a public defender and in private practice. And then I came to the state's attorney's office about 5 years ago with the idea of getting into this position. And I am in this position, and I find it to be the perfect melding of my defense experience and now I have a few years as a prosecutor, as a line prosecutor. So I am not a career prosecutor. I, in my mind, have an idea about what that means or what career prosecutors are like. I'm not one of those, and I don't, even though Lauren calls herself a career prosecutor, she really has quite a broad and open perspective on these cases, which I found very surprising and helpful. So anyway, I was asked to address talk some idea about coming from a defense attorney's perspective or the counsel for an applicant. And one of the things that I thought of, because this struck me when I became a prosecutor, was how many misconceptions I had as a career defense lawyer about what the prosecution's job actually is on a granular, day-to-day, case-by-case level. And what I've learned is that that I came in with misconceptions, and so that's one of the things that I wanted to address. Lauren has already talked about some of those in terms of the prosecution's obligation, not just to correct a wrongful conviction that we discover, but to also, if possible, prosecute successfully the actual perpetrator if that person is able to be identified and is in a position where they can be prosecuted or where they could be prosecuted. And so a lot of that has to do with maintaining the integrity of that sort of parallel investigation that might exist in terms of the live suspect. And I think that there is a difference. So I think it's a matter of expectations when you're meeting with an applicant's counsel. It might be as detailed as a formalized written MOU, or it could be something less formal, but where there's a discussion in the beginning of the collaborative relationship, if it's going to actually become and remain collaborative, about what are the expectations of the defense of the applicant's counsel versus the prosecution, et cetera. And one of the questions that comes up is, in a live suspect case, is that if there is a live suspect identified who's available for prosecution, at what point would the exoneration occur? At what point would the state's attorney's office or the district attorney's office agree to go forward with the exoneration? Is it at the point where the alternative suspect is convicted, charged, probable cause to arrest that other person, or some other standard? And so that's a question that a CIU, I think, has to have internally about what is that level of indicia or certainty that the person who has been convicted is wrongfully convicted, and what, if any, relationship does that have to a prosecution of an alternative suspect? Is there a relationship between those two things? And that's a question that has to be, I think, discussed internally. And then that's something that has to be discussed, I think, with an applicant's counsel. Because if it's going to be a higher standard, like we're not going to go forward with an exoneration until that live alternative person is charged, or there's probable cause to charge that person, then those are expectations that need to be discussed. because there are probably a lot of reasons why even there's a viable alternative that a prosecution may never actually occur. Another issue is when there is a live alternative suspect, to what extent can counsel discuss with the applicant information about that parallel investigation into the live suspect? And that's something that should be talked about up front, because, you know, if I'm a defense lawyer, if I'm the applicant's counsel, I want to talk to my client and give as much information as I have, but there may be situations, and there will be situations relating to a live suspect investigation where that might not be appropriate from the prosecution's perspective to be able to maintain the integrity of that other investigation. And I'm ranging everything from just reaching out to a potential new witness that's been discovered, to the potential live suspect, to up to and including, I guess it could happen, you know, some sort of intimidation relating to making sure that that other live suspect, you know, that people provide information that may or may not be true about that other live suspect to the benefit of the person who's applying for exoneration. So those are, and that comes back around to trust, where, you know, applicants counsel, where the Innocence Project or private counsel, or whoever it is that may be representing the person applying for exoneration, that's an issue that has to be discussed. And those sorts of, at least general outlines, should be discussed early in the relationship. Otherwise, I think that, you know, run into roadblocks when the defense feels like suddenly the state is putting up roadblocks to the exoneration, that, you know, and it's not that, it's just that the prosecution has the other dual responsibility. We in Baltimore, at least in my tenure, we have not done any formal confidentiality agreements. Is that correct, Lauren? Because we have had
That's
such.
right. That's right, Linda. No, we have not.
Because we have a very, very good collaborative relationship, as Lauren was saying earlier, with Mid-Atlantic Innocence Project and with the UB Innocence Project Clinic. So it has not become an issue, but, you know, personnel are starting to change now. And so that could become an issue that we're going to have to raise and address more closely. And, you know, we're always thinking of new issues that come up in our minds that we think, gosh, you know, never thought about that before. And that's something that needs to be discussed, like this whole issue of what level will you go forward with an exoneration in terms of where a possible prosecution might be of another person. So these are all issues that come up, and it's complicated. And the more I think that defense counsel or the applicant's counsel and the CIU can discuss it in advance to the extent they're able to think of it, that's going to make for a more trusting relationship and a better collaboration.
Linda, can I ask this question? Do you think it's possible to have a
I'm so sorry.
a policy regarding the stage at which an incarcerated applicant would be released or exonerated when there's a third-party suspect, or do you think it's always going to have to be case by case?
I think it's going to have to be case by case, but I imagine that there could be some state's attorneys or district attorneys who may feel differently. And that's why I'm saying that's a discussion that probably needs to happen internally in the prosecution's office, so that then that can be conveyed or communicated to applicants coming in.
Right. Well, and it's certainly in our limited experience, which is, you know, at this point, very limited, but it's certainly an expectation on the part of victims' families that
Right.
if they have an idea that there's a third-party suspect, that it's going to be a swap, you know, in and out, which obviously we try to do everything we can to correct that oversimplification, but it's hard, you know, it's hard, it's difficult if they have an idea that that's the concept. Well, thank you, though.
Thank you.
That's one thing.
Someone here is asking about, is there a collection of sample collaboration agreements? And Marissa says, if everyone could see that, to go to the website convictionreview.net, where they have some of those collected.
Thanks, Linda. And also, if folks have examples that you don't mind sharing and being made public, please feel free to send them to me directly at mblu@law.upenn.edu, And we'll kind of add them to our collection and make them available for people when they need them.
So Lauren and Linda, I think you guys both brought up points that bring us to ethical issues, right? There could be, a lot of ethical implications for us as prosecutors when we're looking at these cases, and not just on regular cases that we do investigations that we don't have live suspects for, but there's also those considerations when you do have live suspects. And, every jurisdiction has ethical rules that we have to abide by, when you practice in that particular jurisdiction. And, all of us as licensed attorneys have to abide by ethical rules, but prosecutors have special ones carved out for us. And in addition to those ethical rules, you might find some additional information, additional rules or restrictions that are attached to us in, your state code, like there is in Texas. And then you have your office policy that you have to think about as well. So, is there any consideration, Sarah, that you'd like to share with us also, touching on what Lauren and Linda talked about, that, will allow us to consider these ethical issues from the prosecutor's viewpoint?
I agree, Cynthia. There's so many ethical obligations that we need to keep track of as prosecutors, because we do have a high bar for ethical concerns some backup noise there. As prosecutors, we are pursuing a case in the interest of justice, not for accused defendant or a live suspect or a victim. We need to proceed in the interest of justice at all times. So it's really can be tricky sometimes balancing some of those ethical issues, and balancing in particular the expeditious relief for a potentially innocent person when you are pursuing the integrity of a conviction for a new prosecution of perhaps a true culprit at this point. So balancing those and the intricacies of that investigation, a parallel investigation, can be very complicated. And I think in some ways, Marissa has set this up in regarding having prosecutors speak in regard to this and getting the defense perspective. Because in some ways, being the prosecutor or a career prosecutor as a conviction integrity unit director, there can be some benefits. And obviously, we've all looked into some of the national standards regarding whether it should be a prosecutor as the CIU director or a defense attorney as a CIO director. And there can be pros and cons to each one of those. Doing a parallel investigation can sometimes, there can be a benefit to having a prosecutor involved, because there are so many investigations that a prosecutor has been involved with. Starting with, of course, assigning an investigator. Who should be involved with that investigation? Should there be a police officer involved? Should there be an investigator who's assigned to a conviction integrity unit? And how should that investigation proceed? And in our county, we have a fairly large county in Middlesex County, which is across the river from Boston. And we have 54 different cities and towns that we have to take into consideration. So we have state police unit that is assigned to our office. And then we have individual local police departments that we would take into consideration for every investigation. And one advantage starting an investigation post-conviction is that you would more likely have a choice as to who to choose for that investigation versus prior to when you are prosecuting a case and you are just almost assigned the investigator or the police officers involved in the case. So taking into consideration who should be assigned, whether there's any potential misconduct for the office who was involved, the police department involved, is that a consideration you need to consider in assigning that officer? Sometimes there is a benefit to having a local police officer assigned to the case versus a new investigator who's not been involved at all, because they might have some context as to what was in that location perhaps 30 years ago, what was present at the time, the angles. If there's a concern regarding an eyewitness identification, sometimes getting the perspective for someone who is familiar with the lay of the land versus someone who does not know what was there and present 30 years ago, there can be an advantage to that. But that being said, you need to also take into consideration whether there's any potential concern for misconduct for an officer who was involved in that agency 30 years ago, and you may not want that department involved, and you may need to make sure that that department is not involved in any way, whether it be you have a state police investigator assigned or a private investigator assigned. Those are all considerations. Our unit does not have investigators assigned to the unit or dedicated to the unit. But I know many CIUs have investigators separate from police departments who are involved with and assigned specifically to the units. Making considerations regarding interviewing new witnesses and re-interviewing old witnesses and evaluating how to proceed. I think Lauren made a lot of great points regarding interviewing witnesses, and we do try to include defense counsel in joint investigations when we're able to. However, when there's a live suspect, you can obviously, as Lauren pointed out, there's a reason why you may not be able to include a defense attorney in that live interview. However, where it's not a live interview, a live suspect, there can be a real benefit to including the defense counsel in that interview. So I think there can be a benefit to both sides, not just the defense for being in on the investigation and getting all of the information head on, but sometimes the witness is brought to us through the defendant's attorney or through a connection through the defendant. And sometimes there can be a trust and a cooperation that can be built by joining with the defense. So it's building that, that trust and the relationship that with the prosecution and the defense, as well as with the investigators, I think that will make it to be a more of a positive parallel investigation. It's important also to evaluate the evidence that you have on the case, whether it be any new evidence that comes up or evaluating the old evidence and determining whether there should be additional forensic testing that might need to occur, evaluating the condition of the evidence. And those are all some concerns that you need to take into consideration regarding the condition of the evidence. You know, ethically speaking, who had the evidence, who touched the evidence? Was it the police who were involved? Where has it been kept? These are all considerations that you need to take into consideration when you're dealing with this parallel investigation, while still balancing that concern for an expeditious relief to a potential innocent person, but maintaining the integrity of that conviction as you're pursuing this new third-party suspect or new potentially true culprit. And it's important to balance that trust. As I think Lauren said also, having that relationship with your innocence organization, I think is really important. There are many times where I've offered attorneys to come to interviews, and many times they've declined and wanted to interview suspects on their own individually. But when you are able to balance that relationship with the innocence organization, which most of you likely have already cultivated that relationship, then typically there's a trust there that exists, that realize that the benefit of being present together and proceeding together can help both sides. The other thing to consider also is the trust relationship with your trial team. At some point you need to consider whether when you're pursuing the prosecution versus reviewing the case for exoneration, and your office likely will not be prosecuting the case as the conviction integrity unit. And if it proceeds to prosecution, you need to determine at what point to bring in a trial team and at what point the trust relationship would exist with that trial team versus the conviction integrity unit within your own office as well. And that can be a benefit, again, also to someone who's been a prosecutor in the office. You might already have a pre-existing relationship that there can be a trust there. But if you don't have a trustworthy relationship within your own office regarding the trial team, you need to take that into consideration, because if there might be situations where there might not be public information yet regarding this live suspect or a third-party culprit, and you need to keep some of that information potentially close to the breast while you're pursuing that investigation, again, while still balancing the needs for this expeditious relief for an innocent person. So there's a lot to take into consideration. At what point do you pass the baton to a trial team for them to pursue the prosecution? And at what point does the review of the exoneration end? And I think that's really has to be considered on a case-by-case basis. And it's hard to consider that on a general, kind of a system management program, but versus it has to be really a case-by-case building that relationship. And one thing I think is really important to mention also is victim contact, that this is a really critical piece of prosecution when there's a potentially innocent person and a potential true culprit that you're pursuing. And that's a really difficult conversation to have, but you have to make sure that you keep into consideration the rights of a victim and how traumatic that can be, of realizing that the person that was convicted 5, 10, 30 years ago may not be the person that actually committed the offense. If that person is still alive, if it's not a homicide, in particular for sexual assault investigations. That is a traumatic conversation to have. If it's a homicide investigation, speaking with the family regarding that there might be another individual who's involved, or hearing that there may be an exoneration in a case is a very traumatic conversation. But it's important to try to have that conversation as soon as you can, but not before you're able to have that conversation. There's many of you probably heard about Jennifer Thompson and Ronald Cotton, who wrote the book Picking Cotton. And that's a great example of a sexual assault victim who was notified that it was that the person who was convicted of the rape investigation was actually exonerated and was an innocent person. And they have had an incredible relationship after that time period, and the book is a great example, and their relationship is a great example of being able to move on. But when do you have that conversation is difficult to determine, because, as I said, you want to have it as soon as possible, but you can't have it until you perhaps have all your ducks in a row and you're able to proceed with potentially a new prosecution, or you're able to have something revealed that where someone wouldn't perhaps there be a custody situation, or to tip someone off and maybe not be able to proceed with the true prosecution. So it's really important to take all these into consideration with the relationship with the defense counsel, relationship with your investigators, and it's really important to take into consideration the relationship with your victim and having that conversation. And more than anything, making sure you defer to your district attorney and making sure they're in the loop at all times, because it's the district attorney's prosecution, and need to make sure that you defer to that elected official regarding what's proceeding.
Right. That's right on, Sarah. And also, a lot of people don't know that there's a Victims' Crime Act that we as prosecutors have to observe and follow. And not a lot of folks know that. And so that's another important part of the prosecutor's consideration. So I'm so glad that you brought that up.
Yes, and it's, I think, again, a good natural segue into our next speaker, unless there's questions pending. Cynthia, did I see some come in?
There was some that came in, and you know, this is really Lauren, Linda, Sarah, Mark, all of y'all, if y'all want to weigh in on this. There was some a question about, you know, why not have the defense collaborate, you know, or be participating in the interview of the live suspect? Why not?
So I actually don't want to infringe too much on Mark's time, because I know we've got another portion of the discussion to get to, but I just, the reason why not is really just going back to sort of recognizing that we've got a live suspect investigation. If you think about it as just an investigation, that's what you're trying to run at the same time as a factual innocence investigation. So it's just like any other prosecution case, any other investigation that would occur, but it happens to be occurring at the same time albeit with incredible complications, but at the same time as a factual innocence investigation. So that is probably the best way to consider that. So I say that because we don't, as prosecutors and our and the police department, we don't bring in defense counsel when we're looking to charge someone. We don't loop in defense counsel when an investigation is underway as to a, you know, just a suspect, you know, in general. And so if you consider it like that, where there's going to be some overlap of certain witnesses, they're going there. So I think that Sarah's brought up, Linda's brought up, there are plenty of exceptions to the rule. However, there will be considerations when we put back on our prosecution hat and we go into the mode of, okay, we've got this live suspect, and how are we going to preserve the integrity of that prosecution? There are going to be some places where boundary walls are going to go up to preserve the integrity of the prosecution. But if you look at it as pre-trial versus post-trial, it might make a little bit more sense. And it is very complicated. Thanks.
It absolutely is complicated.
Also, just want to mention the concerns for there could be potential flight risk if a true culprit is tipped off prior to being able to gather enough probable cause to arrest that person. Also, if there's a concern that the media would be tipped off, you know, before being ready to proceed. Of course, you might just be getting that information in the interview and not being able to make an arrest yet. You may not have had the chance to speak with the victim yet. You need to have all of that information in place before you make an arrest. And if that's revealed outside of the prosecution team prior to that time, it can inhibit the prosecution of the case. And so those are all considerations and there can be ways to proceed with that. There may be a limiting type of agreement. You may need some sort of a court order that you could get for exclusivity, but I think those you need to consider that though when you're proceeding.
I think there's two piggyback questions. Another one is, wouldn't having a police officer interview that live suspect or be with you when you interview that live suspect, if you're even a part of it, wouldn't that kind of chill the effect of that person? Then, you know, they would not want to talk. You know, that's one. And then the other question is, you know, at what point in time do you kind of make the decision, you know, you're trying to exonerate this person, but you got this other live suspect. So you're going to leave this other person in prison while you do this other work. I mean, how do you weigh all that, all those considerations?
So as to the first part, having a police officer along for the interview, I don't know about everybody else, but here in Baltimore, prosecutors are pretty much seen as the police department. And so, and since we are under an obligation to identify ourselves as being from the prosecution office, we don't really see much of a difference in terms of whether we're the ones interviewing versus the police department. And quite frankly, it's just something that we have to deal with. I mean, there's just no way around it. And then I would just, I think that Linda and I think Sarah touched on it already, but in terms of when we have determined that we here in Baltimore, and I don't know that I've heard of any jurisdiction, or maybe I have on the news, but we don't leave a person who we find to be factually innocent. We do not leave them in prison while we look, you know, while we finish out an investigation on an alternative suspect. And so I think the clear majority of the time, and I think that you'll hear it on the news if this procedure is not followed, but a clear majority of the time, if we have a situation where there's a factually innocent person sitting in prison, that person is released, and then we sit with an open case, and that might be from now until the end of time. But that is typically what happens, and definitely here in Baltimore, that's what happens. Thanks.
So I think that takes us to our last speaker for the day, which is Mark Hale, who needs no introduction to this group, I don't think. And he's going to talk about what must be the very sticky issue of dealing inter-office when you are a CIU or CRU within a single prosecuting agency. So, Mark, I'll turn it over to you.
Thank you. I will try to be brief because I know we don't have too much time here. The real question is when you're dealing with a CRU is how you interact with other people in the office, and there's certain pressures that are involved in that. I can speak to that because I fall into that career prosecutor category, having worked as a trial prosecutor for most of my career, and that the CIU CRU title came very late in my career. Before there were CRUs, how did live suspect cases get handled? And the short answer is that they didn't. If they came up at all, they came up in the form of post-conviction motions by the defendant, in which they would try to establish that had it was known about this other suspected person, they would be more likely that they would have had a favorable outcome at their trial. However, that often was blunted by procedural means if this information was available to any of the parties, or should have been available to the parties at the time of the original prosecution, and they wouldn't get a day in court to have factual recognition or discussion or deliberation upon whether the alternative suspect was in fact the right man and the client the wrong person, and whether he was wrongfully convicted. That was also doubled by the function of the people that were answering those post-conviction motions in a particular office. And those of you who are in prosecutors' offices know that there are units which specifically handle post-conviction motions, whether it's your appeals bureau or a specific quasi-trial bureau that handles post-conviction motions, is that their job is tasked to defending the conviction, and they defend it upon the standards that are set in your habeas petition or your statutory post-conviction scheme. And so again, oftentimes you would not get a full and frank hearing about a factual determination, and it would be in the context of an adversarial process. Now, of course, all of that changed when we started establishing conviction integrity, conviction review units around the country, who basically are not bound by the procedural strictures of the post-conviction motion habeas sort of consideration. I mean, certainly we can take those into consideration, but the beauty of conviction review units is that we make up the rules, and it's purely voluntary, and it's totally within our discretion how to apply these things. But that caused problems within any prosecutor's office. That is, you would end up with competing factions. You would have people that were within the office whose very essence was to prove a particular person's guilt and then to defend that conviction, versus other people that were looking to see whether that conviction was valid or not. And these sort of tensions, and I think most of you know this, still exists in these offices where conviction integrity units are looked at as sort of internal affairs for the attorneys in the office, that your big brother and that you're looking to see where they screwed up, or that you might have an agenda. That is, you justify your existence by finding any number of people that you're choosing to exonerate. Otherwise, what's your purpose in being around? Unfortunately, that's been somewhat exacerbated by the way in which conviction integrity units are perceived or are judged. Just as we are getting to the point now where most prosecutors who might be labeled progressive have abandoned the old metric for determining whether they are successful prosecutors or not, and that is the conviction rate, how many people that they end up convicting and locking up versus the number of people that they arrest and indict, of abandoning that metric, they unfortunately are using the same metric to judge the efficacy and efficiency of their conviction review units. That is, how many people do you exonerate? And you know, this has become personal for me. It wasn't that long ago that by name and for the reason of my being a prosecutor, a career prosecutor, I was accused of slow walking cases that, gee, you're not exonerating many people as you did before. And that's a problem because you're a career prosecutor. When in effect, you know, what happens is that, as we all know, that you call balls and strikes, that you try to do it as even-handedly as possible. But you even see at this point the defense bar, and that's where these criticisms came from, you know, starting to pile on in terms of what is a successful conviction review unit. And this is also, you have to understand that you know, in a collaborative arrangement, we'd like to all be on the same page, but you have to understand that your innocence people, with the best of intentions, are advocates, and whether they seem to think that this sort of public pressure is the sort of thing that will get them better results is an open question, and probably, in my opinion, not very effective in the whole run. So, you know, the thing about it is there is always going to be these internal and external pressures in terms of when you're dealing with a live suspect case. And to get back to brass tacks, anybody who is coming into the conviction integrity conviction review unit and saying, I'm not the one that did it, they are all some other suspect cases, because if they didn't do it, then somebody else did. My experience a lot of the times that we've had these sort of things that have been brought up by the petitioners in the case is that we don't have a live suspect. The suspect is, in some cases, conveniently deceased, so that you can't do too much about it. But if you do have that case, and you should anticipate that when you have a conviction integrity unit and you have these competing factions within your own office, that you've got to draw certain lines, that you have to make certain establishments before you even get into the business. And then once you have made those distinctions, those lines, then the job is to stay in your lane, basically, so that you don't have people competing at cross purposes within the same organization. And preferably those lanes run vertically. That is, that you don't make the decision, nor does your counterpart who may be in a trial bureau make the decision about when to intervene or get involved in the other's job at the time. It should run in a vertical fashion up to your decision maker. I mean, obviously, if you're the decision maker, then you share what you want to share at the appropriate time. But if your decision maker is your elected, as it was in Brooklyn for me, it was the district attorney, or somebody on your executive staff who has the decision-making process, you don't refer these things out to the other units within the office, because it's not constructive. It doesn't go anywhere. I can tell you from experience that the first blush of your saying or imparting information to the parallel trial team is them trying to prove that you're wrong. Them again defending the conviction. So it doesn't work too well that way. In Brooklyn, what we had done when we initially started the unit, we would take people that had filed post-conviction motions and alleging actual innocence, and we would investigate their cases. The problem is that wouldn't stop their post-conviction case from going forward, and you would have, with apologies to you, Carolyn, you'd have judges trying to muck up and get involved in your investigation, which is, defeats the whole purpose, because these are extrajudicial sort of functions that conviction review units perform. And you would also have your trial team or your post-conviction motion defending team, as it were, since they become the respondent in these things. You know, again, working across purposes, trying to say, hey, the conviction is good and here's why. We remedy that by saying that to the petitioners, it's like, you know, we can't stop you from making a post-conviction motion or starting that sort of action. But if you do, don't come to us. And if we have an investigation going and you initiate something like that, the investigation stops. That's it, you know, and we'll resume it whenever you're done. You know, we don't care about that, but we're not going to do two things at once where we put ourselves in the position of working against one another just because of the inherent way that things are structured within the office. Now, then the question goes is that when you're doing a innocence investigation or a conviction review investigation, how far do you go on investigative means that would, in fact, show that it was somebody else, your live suspect or dead suspect or other suspects did in fact do the crime? And my opinion on that is that you do it only so far as you can or do that it would provide you the information that you need to make the recommendation to your elected and to your court, which ultimately will have to make the decision on these cases, that in fact the conviction against the petition was wrongful. And that doesn't, I mean, listen, we've done, you know, some extreme stuff in the past. We pursued abandonment samples for DNA analysis. We've conducted lineups with, you know, on court order. And a lot of these things might have tipped off people, but the truth of the matter is that it is not our job to establish that somebody else did the case. That is, to put it in a case where it's a prosecution case, that you could go out and make an arrest and get an indictment and go to court and secure a conviction for another person. The way we established the rules was we go far enough that we can make that recommendation that this conviction was wrongful, and it's wrongful because we have evidence or we believe evidence or that shows that person X did in fact do the crime. And then it's up to our elected if he wants to say, okay, because listen, nobody's exonerated, not a convicted person who's incarcerated is not exonerated until your elected district attorney said so, and the court has ratified that particular case, and legally that person has been released. You can have an opinion in a lot of different ways, and sometimes those opinions will trigger Brady obligations, as we talked about a little bit. Sarah talked a little bit about in terms of your ethical obligations. But you have to understand the way that these things are set up. Your guy, your petitioner is convicted and perhaps incarcerated until such time, and you can't do anything about this until you get a court to say, no, that conviction is vacated. And you're legally bound by that. And you can have all kinds of opinions and you can make all kinds of disclosures, but that doesn't have any effect until you actually get that final say so. And all of these things, having go back to a live suspect, should be kept in mind. You know, whereas you want to do enough to show, if you can, if you should, if it's warranted, because again, we don't have an agenda, we're calling balls and strikes, remember? That the conviction was wrongful. And we're not the trial team. And forget about it, you're not going to get any help from the police because they've got a closed case and they will never admit being wrong because that'll open the door to all kinds of civil liability. So there's going to be no help whatsoever. But you've got to leave it up to the discretion of the people that make policy in your office. if you are not in fact the person making policy, as to when the case gets referred and when the person is exonerated and when you should be pursuing another suspect. Now, I'll go on to say this thing because there was talk here and questions and last thing about interviewing live suspects. Well, I've been involved in a lot of investigations for a lot of years, some on innocence most recently, and then for the balance of my career, ones that were providing evidence looking toward convictions, mostly on murder cases. The important thing to realize is that if you're going to interview a suspect, well, first of all, is this: there is very few times when that is going to generate the least amount of information in terms of deciding your case, whether it's wrongful or rightful. The information that you have on your live suspect is not going to be dependent upon what they say when you interview them. If they say anything at all, they'll probably lawyer off. But it's mostly dependent upon what you get from other witnesses as to whether you've got somebody else as a live witness, or whether you get from other forensic witnesses, whether trace evidence comes back to identify another person. So the whole question about sitting down and talking to your live suspect is generally a moot one. It's just not going to come up. The more tenuous question is, when is it within your universe where you're going to make the recommendation based upon your belief or the evidence that you have found that shows that somebody else did it as opposed to your petitioner? That's when it's going to become more critical in terms of how it is handled within your office. And my position is that again, there should be firmly established rules about this, because we should all, whether you're starting out or whether you're continuing or whether you've been doing this for a very long time in terms of conviction review, you should realize that this is going to become an issue at some point. And so in establishing this or maintaining your unit or making your unit a legacy, you should seek to have these sort of rules made by your elected or your executive staff so that you don't run into these problems in the future. Because a lot of what is built up in terms of conviction review units is trust, not only with the public and not only with the defense bar. And yes, I've been criticized for that sort of stuff, and that goes with the territory. But the main thing is trust within your own office, so that your office changes, so that your office learns, so that your office doesn't make mistakes in the future. So, that sort of trust thing has to be established. And if you don't have these lines, if you're operating willy-nilly and you're making decisions for other people in the office as to what they should or should not be doing with a particular case, then you will lose that trust, and you will lose actually the integrity of what you're doing in conviction integrity. And that's something you have to work at every day.
Thank you, Mark. Lots of good points, lots of good comments from you, Mark, and all of our panelists. I think we're probably out of time, unless Carolyn, you have anything else?
No, I just want to thank Marissa again for getting this together. It's super helpful. I think it certainly is for our office, and it prompts more questions, but gives us an idea of where we can go for some answers, or at least discussion. So I see a note from Marissa asking us to complete the survey. And
I'm going to launch that right now, but I didn't want to do that before thanking Cynthia and Carolyn, of course, for your time, and everybody, Lauren, Sarah, Linda, and Mark, especially for coming out of retirement for us. We're very grateful. As always, I think we raise more questions than provide answers, but I think that's a good part of what we are here to do together. And just want to remind people that next month we will be continuing on this theme. We will be talking a little bit more about suspect investigations and interviews, as well as some of the other issues that come up through live suspect investigations in particular. So just Cynthia, Carolyn, my absolute gratitude. Thank you so much for your help. And Lauren, thank you for putting this together and your ideas. And as always, thank you everyone for joining in. Please complete the exits poll before you leave so that we can report this back to BJA. And we'll put that in, who has sponsored provide the financial support to be able to provide these meetings for you every month. And we'll see you next month. Thanks, everybody.
Thank you.